You don't need to be a permanent resident of Canada to file for a divorce in Canada if you've been living in the country. Even if you're not a Canadian citizen or PR, as long as you've been living in a Canadian province for at least 1 year, you can still apply for a divorce in that province. This means that temporary residents such as work permit holders, students, or people on visitor visas can also apply for a divorce in Canada as long as they meet the residency requirement. Another important thing to note is that your spouse doesn't have to be living in Canada or living in the same country for you to get a divorce here. As long as you meet the residency requirement, which is living in the province for at least 1 year, the fact that your spouse might be living in their home country or somewhere else in the world doesn't prevent you from starting the divorce process in Canada. The Canadian court will consider where you've been living regularly, also called as your ordinary residence, and not where your spouse lives. Even if your spouse hasn't been in Canada at all during the past year, the Canadian court still has jurisdiction over your case as long as you meet the residency requirement. So you don't need to worry about whether your spouse is in Canada or not. You can still move forward with the divorce process on your own. If you have more questions, feel free to reach out.